Also breaking this afternoon, it's been a point of political contention for more than 2 years. Now a portion of the Safety Act that will go into effect will soon eliminate cash bail in Illinois.
WGN political reporter Taman Bradley is live downtown with reaction from both sides. Taman?
Dina and Ben, last fall, 100 of Illinois' 102 state's attorneys opposed this law. Now they'll all have to enforce it. Now that Illinois' highest court has upheld the law eliminating cash bail, state's attorneys like Kim Fox have 60 days to prepare.
We will have staff who will be able to vet these cases in bond court to make sure that these hearings are going off well and to make sure that the public is safe.
In the 5-2 decision split along party lines, the justices ruled that the law does not violate the state's constitution. Chief Justice Mary Jane Tice, writing for the majority, the Constitution does not mandate that monetary bail is the only means to ensure criminal defendants appear for trials or the only means to protect the public. Fox lauds the ruling as a victory for economic and racial justice.
It feels good to be on the right side of history. The reality is that we knew that this legislation was constitutional, and the reality also was that we had a bail system in place that was not necessarily keeping our communities safe, that was keeping people locked in jail pre-trial simply because they were poor and not a threat to the public.
The decision is a win for Governor Pritzker and the Democratic-controlled legislature, who for years faced criticism for pursuing no cash bail. In a statement, the governor said he was pleased with the decision. We can now move forward with historic reform to ensure pretrial detainment is determined by the danger an individual poses to the community instead of their ability to pay their way out of jail. That view is not universally held. 58 county state's attorneys fought the law, arguing it will make communities less safe. Bob Berlin is the DuPage County state's attorney.
If we show that someone is a threat to persons or the community, for most violent offenses, judges are going to have the ability to detain people without bond, and I am confident that they will do that. But unfortunately, there are still some offenses, burglary being one of them. Unless there's injury to a person during the course of the burglary, judges will not have the ability to detain people for burglary.
Jamie Mosser is the top prosecutor in Kane County.
I remain concerned that we're going to see spikes in certain areas of crime and certain people because we can't hold them.
Defendants currently being held because they couldn't pay bail will be able to petition the court for pretrial release beginning September 18th. We're live downtown. Taman Bradley, WGN News.
Thanks, Taman.
And following up on that, advocates say they don't have a realistic count of how many defendants the change could impact. Cook County's public defender argues money previously spent on bail could instead be put back into the community.
The decision on who goes to jail or who doesn't will no longer rely on how much money your mother has or your partner has or your grandmother has or your church has or you have.
Illinois Senate Republican leader John Curran wants lawmakers to head back to Springfield to address lingering concerns from law enforcement. But that's not likely to happen. Governor Pritzker already signed off on some tweaks to the bill last year. Stay with WGN News for continuing coverage of today's ruling. We'll have reaction on the WGN Evening News and a complete wrap on the WGN News at 9 and 10. You can also follow our coverage online at WGNTV.com and with the free WGN News app.